सारे एथलीट्स हैं जो मुझसे बेस्ट हैं ऑलरेडी वर्ल्ड में, लेकिन उस सिचुएशन में हम कैसे उस प्रेशर को हैंडल करते हैं और कैसे परफॉर्म करते हैं, क्योंकि वेदर का, हवा का बहुत फ़र्क पड़ता है हमारे गेम में। तो मुझे लगता है कि वो सबसे अच्छी चीज़ है। मैं बस अपने आप को कंसिस्टेंट रखना चाहता हूँ और 90 मीटर का मार्क भी हो ही जाएगा, हो जाता है वो भी, मैं लाइन से आधा मीटर पीछे था तो अगली बार थोड़ा आगे से फेंक दूंगा।
थैंक यू।
चाहे महिला हो या एथलीट हो, दिमाग पे गोल्ड ही रहता है।
Thank you so much. Anurag ji, stay with me. Neeraj, thanks a lot. A big round of applause, please, for our Indian of the Year sports. I don't think it comes anything bigger than this.
It is said that an athlete cannot run with his money in his pockets. He must run with dreams in his heart and determination in his head. These hopes and dreams.
The Indian of the Year made a grand return after a 4-year hiatus, and it's broken and smashed all records. Packed to the rafters auditorium, the Darbar Hall at the Taj Palace, that was a venue for the Indian of the Year 2022, also saw huge amounts of engagement all across the digital space. It trended at #1 nationally for more than an hour. Allu Arjun's award speech has already got more than 1.3 lakh plus views on YouTube. Allu Arjun, Neeraj Chopra, Pushpa move has got more than nearly 18,000 views on Facebook. The external PR and media coverage by 18 Indian and global online channels is there for everyone to see. And of course, the viewer feedback has been phenomenal. We thank you for your constant support. 6 months, we are #1. And of course, with the Indian of the Year Awards 2022, you have helped us prove to the world that this is the platform and this is the destination to be. Now, we had a huge slew of ministers from the government who had also graced the event and very, very kindly agreed to present the awards to our champions, our Indian of the Year, across 6 different categories. Union Minister Nitin Gadkari ji was also there. He's the Union Minister for Road Transport. And in a conversation with Chandra Srikanth, she talked about the future of cars, alternative fuel cars on Indian roads. Have a look.
So you have to tell us, it's powered by hydrogen. It's powered by hydrogen, as you can see. Tell us about this vehicle, sir.
This is the first vehicle in the country which is on hydrogen. There are 3 types of hydrogen. One is petroleum hydrogen, that is coming from petroleum. Other is black hydrogen, that is coming from coal. So brown hydrogen is from petroleum. And this is the green hydrogen is from water and from organic waste. We can get methane and by that we get green hydrogen. So this is the first car. The name of the car is Mirai. Mirai in Hindi it means that Bhavishya. So I feel that the hydrogen car is the future of this country. We can get green hydrogen from sewage water and organic waste. Already municipal solid waste we can segregate, and by which we can make the green hydrogen, and we will export green hydrogen to the world. That is the dream.
Minister Gadkari clearly walking the talk, or rather driving the talk when it comes to renewable energy. As he said, green hydrogen is going to be the bhavishya for India. When do you see widespread adoption, sir, as far as this is concerned?
The process is already started. The green hydrogen mission is there, and I feel that in due course of time, we are in the process. Within a year, we will get the car, truck and buses on hydrogen, and 100% I am confident that our farmers will generate green hydrogen, and they will be not only annadata, they will be urjadata.
Right. Mr. Gadkari, just a couple of more questions before we take you inside. Yesterday you had also unveiled the opportunity for flex fuel in India. Can you take us through that? What kind of incentives?
The meaning of the flex fuel is, in place of petrol, we are using 100% bioethanol. The rate of the petrol is 120 rupees per kilometer and ethanol rate is 60 rupees per kilometer with the same mileage. And that is exactly at the same time that 1 liter of ethanol is also they are going to generate power. The 40% the vehicle will be on the power and 60% on the bioethanol. So the average it will be whatever we are taking 1 liter of petrol of 120 rupees, where by taking this consideration it will come to 25 rupees per liter petrol.
Right.
And it is cost effective, import substitute, pollution free and indigenous. It will be there because Toyota is going to manufacture this all type of car here, and all the other people also will start, and that will be really a golden era for the country. That we are our petroleum import is of 17 lakh crores, and the day will come that our farmers will generate the fuel. And that is to be a great thing for the rural agriculture and tribal India.
One question that all startups have: what incentives can we expect to boost battery charging and infrastructure in India?
Now for electric, we don't need any concessions because already there is a waiting list now.
Right.
In the some of the electric car, there is a 1 year waiting list. So now there is no problem. When the volume is increased, cost is going to reduce.
Right. By when can we, in terms of the electrification target for Indian Railways, that's also something that's very
That
high.
is not with me. But regarding the automobile sector, now the future is for electric, ethanol, methanol, biodiesel, and even we can Parali, which is creating pollution problem for Delhi. We are making bio CNG and bio LNG from Parali, rice straw. And 1 ton of 5 ton of Parali is giving 1 ton of bio CNG and bio LNG, and the tractor and truck and buses will be run on that.
Last question, Mr. Gadkari. A lot of EV enthusiasts in India often ask about Tesla and Elon Musk. Where are the discussions there, sir?
We have got all type of brands. We don't have bother about anything. The people who want to manufacture here in India, they are all welcome.
Right.
But manufacturing somewhere in the other part of the world and taking market in India, it is not going to work.
Make in India, make for the world, and for, of course, the Indian market. That's the message. And even as he says, alternative fuels are here, and they are there here to stay. The first of the hydrogen and alternative fuel cars being driven by Mr. Gadkari himself. The other big star, along with a host of stars, was also one of our awardees, the Indian of the Year in the category of entertainment for 2022. Superstar, now a global superstar, Allu Arjun, who had a fantastic message to deliver. That about celebrating the diversity of India and of course his signature dialogue from Pushpa the Rise. We wind up on that note.
We are, it's unity in diversity. Each of us have our own regional language, but now it's so beautiful that all of us are stepping into this, pan-India zone where, language is no big barrier. Cinema is celebrated all over. People are watching. We used to watch movies from the north. We never used to look at it as a very different cinema industry. We love north. We grew up watching north movies. We admired Hindi cinema, other cinema, Bengali cinema. And now even people are watching South films. So it's all a beautiful cross culture, and I think we're in the best times. I'm very glad we do have our differences, like ma'am was saying, that it's north, south. Yes, the beauty of this country is the diversity. But when this movie was made, it was celebrated by India. So we are all sons and daughters of the Indian film industry. So we're all proud that it is Indian cinema's victory. And we're so glad that we could service the country with entertainment in these tough times.
Sadhu. Well said, sir. Well said.
Thank you. And Indian cinema, India, kabhi jhukega nahi. Thank you. I wanted to give it with a punch.
Sahi punch diya.
Thank you.
Good evening, hello and welcome to Viewpoint. I'm Anusha Soni. The Supreme Court handed down a split verdict in the hijab matter. The two judges on the bench had divergent views. While the split verdict paves the way for a constitution of a larger bench, the ban on hijab by the Karnataka High Court remains effective, and that's the legal position right now. As a sharp, polarized debate pans out in the public sphere, the top court of the country will have to settle some important questions. First of all, what are the limits of individual freedom? To what extent can the state-run institutions curb upon religious expression, and whether the right to privacy and dignity is violated if Muslim girls are asked to remove their hijab in classrooms? We'll talk about all these aspects. First up, a special report.
There is no end to the hangama over hijab. 7 months after the Karnataka High Court upheld a government order banning hijab in educational institutes. Petitions challenging the hijab ban led to a split verdict in the Supreme Court. While one judge, Justice Hemant Gupta, dismissed the petitions, the other judge, Justice Dhulia, was of a differing opinion. He said asking girls to take off their hijab is an attack on their privacy and dignity. He said that under the Indian constitutional scheme, wearing a hijab should be simply a matter of choice. It may or may not be a matter of essential religious practice, but it is still a matter of conscience, belief and expression. He said the government order and restrictions on hijab goes against value of fraternity and human dignity. The case has also to be seen in the perspective of the challenges already faced by a girl child in reaching her school. And are we making the life of a girl child any better by denying her education merely because she wears a hijab?
प्राइम मिनिस्टर से सबसे पहले मैं ये अपील करना चाहूँगी कि वो हमारे एजुकेशन को हम पे छोड़ दें और हमारे हिजाब को उसमें कोई कॉन्फ्लिक्ट ना बने हमारा हिजाब, क्योंकि देखिए हिजाब हमारा राइट है और हमें इसको फॉलो करना है.
The matter will now be placed before the Chief Justice of India, who will constitute a larger bench to hear the case afresh. Till then, the hijab ban remains in place.
I expect the judgment, definitely it will be in favor of Karnataka's rules and act. Whatever the rules and regulations which have been followed now will be valid till the judgment of the higher bench comes.
But many in the opposition are hoping for a more favourable order from a larger bench.
जो हाई कोर्ट का जजमेंट था मेरी राय में इट वाज बैड इन लॉ, बैड इन टर्म्स ऑफ इट कंटेंट्स और इट हैड मिसयूज Quranic commentaries and translation. This has serious ramifications, should not have been allowed.
But at a time when women worldwide are demanding not to wear the hijab, can individual choice override institutional autonomy?
Well, let's take a look at the key pointers of this split verdict and how essentially the two judges on the bench, Justice Hemant Gupta and Justice Dhulia, differed in their opinions about this matter. Justice Dhulia said that quash the government order of the 5th of February removed the restrictions it's violative of their right to privacy and dignity under the Puttaswamy judgment, the 9-judge bench judgment of the Supreme Court of India. Justice Hemant Gupta said that there is a divergence of opinion. He more stressed on the need for, uniforms, how they are important, how there are limits to secularism, and how institutional autonomy is very, very important. Justice Dhulia venturing into essential religious practice is not needed at all. He said the test of ERP, essential religious practice, is not important. It's a matter of choice. Justice Hemant Gupta said that hijab is not part of the essential religious practice. He agreed with the Karnataka High Court and what was said earlier. It's a matter of choice, nothing more, nothing less. He went on to say and make some very strong comments about the fact that when you ask a Muslim girl to remove her hijab, her dignity is violated in some way. That's what Justice Dhulia has said. But Justice Gupta disagrees. He says that the Puttaswamy judgment is a new jurisprudence which is emerging. And it is not correct to simply copy-paste the judgment. There has to be limits as to how privacy is going to survive within the institutional norms. Education of girl child is important. It's a matter of individual choice. Justice Gupta says that management taking a call on uniform not violative of fundamental rights. Many would argue, is this a legally tenable argument? This is a very emotive appeal that court is making, but to what extent is this legally tenable? I want to cut across to my colleague Harish Upadhyay, who is with us on the broadcast. Harish, we broke down the legalities of this order, how two judges disagreed on different views that they had. In Karnataka politics, how will this split verdict be seen? More importantly, right now it's the Karnataka High Court, which is, the earlier order which had come in, which is the correct position of law because law wouldn't operate in a void. But from the side of the government, in the run-up to the elections, will this issue continue to dominate the political discourse?
Absolutely. The Karnataka government, in fact, interprets this order as a continuation of a process. They are saying we wanted to deal with this legally. We brought in an order, then the Karnataka High Court upheld that order. Now the Supreme Court has given a split verdict, but we are very confident that when this goes to a larger bench, the points that we have made will also be upheld. They are saying the fact that their order hasn't been quashed completely by this particular two-judge bench means that they do see merit in some of the arguments made by the Karnataka AG. At the same time, remember, it's not just the government. The petitioners too are claiming that they too have something to take from this split verdict. They are saying for the first time in their entire legal battle, they are seeing some hope. Some of their points have been brought. In fact, some of the points made by the petitioners have been echoed or mentioned in the order passed by Justice Dhulia on whether the privacy stops at any particular place or it goes with the person, and why should school be any different, or the fact that it's not just about religion, it's also about choice, it's also about Article 19 and 14. So the petitioners believe that they have seen some positive in this. For the first time in their entire legal battle, they have at least one judge who's believing and taking some of the points made by them.
Interesting. And as you rightly said, Harish, this is going to have implications in the politics of Karnataka as well. Thank you for joining us on the broadcast and getting us all those details. Joining us on the broadcast is our full panel of guests, Mr. Ashwini Dubey, who's a Supreme Court advocate, Abha Singh, who's a lawyer, Mr. Ratan Sharda, who's a researcher, also a political analyst and author himself, is joining us on the broadcast. Shraddha Bashish Shivana, who's an advocate petitioner, is also joining us on the show. Mr. Ratan Sharda, I want to begin with you, and I want to quote you the portions that the Supreme Court essentially has spoken about. This is something that Justice Dhulia has said, that by asking the girls to take off their hijab before they enter the school gates, it's an invasion on their privacy, it's an attack on their dignity. Ultimately, it's a denial to them of secular education, violative of Article 19(1)(a), 21 and 25(1). Do you agree with Justice Dhulia? In the spirit of a constructive discussion around the Supreme Court judgment, once again, there's one judge on the bench who's saying that somewhere you have violated their right to privacy and dignity. Mr. Sharda.
Well, when it says that a secular institution, secular education, that to speak of removing hijab as an invasion of privacy, I think this is very, very Sharia argument. This is not a secular argument. He also talked about dignity. So does it mean that the women who don't wear hijab or scarf or something, they are undignified? And secondly, I have a paper with me, the copy of the particular circular of the school. Actually, I don't know why this confusion. It clearly says girl students are permitted to wear the scarf inside the campus. Scarf is hijab. Okay. However, the color of the scarf should be that of the dupatta. No student be allowed to wear any other cloth inside the campus, including the college canteen. Now, scarf is hijab, and these girls were fighting the entire battle wearing burqa. So what is this confusion? Now, let that be aside. What does Owaisi say? It says judges by talking of Quranic commentaries were actually bad in law. So what is the Quranic commentary we cannot comment? My serious issue is we have a serious mix-up of colonial mindset and wokeism. When I say this, remember, courts don't allow any other uniform but the uniform left by the British, which is totally unsuitable for our environment. But they insist on that. If any lawyer goes there, he is fired very well. You have to argument in English because you can't argument in Hindi. But on the same side, the woke side of the judiciary says adultery by the women is allowed because during marriage she didn't profess for loyalty. Then he says puberty, once puberty comes, then girls can be married off. This is against our own law. In constitution, it is against our own equality before law. Further, if you talk about, what will happen to uniform in the uniform of any institution tomorrow? If you say uniform is not sacrosanct, religious diktat is sacrosanct, then what happens tomorrow if in the courts somebody wants to come in dhoti, or somebody wants to come with a dupatta, or somebody wants to enter in police force saying I will not give up this particular
institutional autonomy and the rules which are at the court here. Opening up of Pandora's box. Abha Singh, I'm going to take that argument to you, and legally speaking with you, just because a Pandora's box may be opened, does that stop the courts at looking at constitutional questions? These are questions of liberty. These are questions of limitations of Article 25. More importantly, and this is for the benefit of our viewers, how various fundamental rights interact. This is about the freedom of religion, but do you also have a right to expression? If you have a right to expression, then what are the reasonable restrictions that the state government can put in? All these critical questions will have to be answered by the Supreme Court, even if it opens up Pandora's box, I argue.
Absolutely. Even if a Pandora's box is opened, if there is the country is put to fire, there are fights, but the courts duty is only to go by the law. Their duty is only to see whether the constitution, the law is implemented the manner in the way it should be done. So if you remember Mandal, there were students who were burning themselves in Delhi University. There were protests all over. So many young children died. But yet Mandal reservation was implemented and it was upheld. So here also, you have to see that if the court's duty is only to see whether the law of the land is being upheld or not, nothing more, nothing less. Now coming to hijab, the bigger issue here is because one of the tenets what the earlier speaker was saying, the school uniform. Definitely a police uniform. If a officer says, no, I will not wear the uniform because I am supposed to wear a hijab. So there it will become a very important issue. So on that ground, if you go by the Karnataka Education Act, they said school uniform has to be similar, and on that matter, so many schools have a uniform. So that is why it's a split verdict today, because it's not very easy for the court to come to a clean judgment that yes, hijab should not be allowed, because on one hand you say it is not an essential practice, which to some extent is true that it is not an essential practice, but yes, if it comes to discriminating against these girls, if it comes to violating the dignity, these are larger aspects. If it comes to gender discrimination, I think a larger
Abhaji, doesn't it perplex you as a lawyer that in this country, when we talk about women's rights and ensuring that there is more gender parity, we are essentially seeking rights for some women to wear hijab inside the classroom. There is no prohibition on any kind of religious attire in this country. You can wear whatever you want. But when there are government-run institutions, there are rules. Even in the campus, they can wear a hijab. It's only inside the classroom that they cannot wear. So are we going to take this absolutist argument when it comes to individual choice? Because I don't think an absolutist argument is even tenable in law.
Absolutely, absolutely. You know, schools have a right to have a uniform, and I think it is the politicization of this event. I am surprised that these young girls who should be studying are coming out and doing dharnas and protests, which clearly shows that vested elements have come into the picture. And I'm telling you, Supreme Court is going to view this in the right earnest. And definitely when world over, when people are saying we don't want the hijab, how can certain, I would say certain vested interests misguide these girls?
And on that note, I want to bring in Shatabashish Shivana into the discussion. Mr. Shivana, as a petitioner in this case, when you talk about the fact that hijab is an essential religious practice, and then you shift from that position and say that you're also violating my right to privacy and dignity. And I ask this question to you rather provocatively, that are you absolutely confident in your argument of essential religious practice? Because even the judge on the bench, which is on your side of the arguments, which agrees that the Karnataka High Court order is not right, Justice Dhulia says you don't need to go into the essential religious practice, just argue on individual choice and liberty. And that's why he's quoting the famous case of Bijoy Emanuel.
Absolutely. See, our petition had a twofold argument. Our first argument was that the circular issued by the state of Karnataka restricting any religious symbols in schools is unwarranted and uncalled for, and they do not have the necessary powers to do so. We were essentially challenging the Karnataka government circular, which was imposing this restriction. And if they're imposing a restriction, the burden of proof is on them to establish why we're imposing this restriction. Is it violating public order? Is it violating morality? They were unable to establish as to why we're doing this. They said there's some friction between two groups. You know, the Muslim girls and a few boys who are wearing an orange scarf, and that caused an issue of public order. And hence we are imposing this restriction. That is not fair. Now, if wearing of a hijab is violating public order, if I'm wearing a hijab in classroom today, whose public order am I violating? Who is being disturbed by this one?
Why don't we come to the listen? I agree with you. I agree with you on the point of public order, and it's a very restrictive approach that most courts take when it comes to public order. You cannot stop a movie from being released because there's public order. You cannot stop somebody from doing something because there will be protests. You cannot threaten the law and order machinery. I don't think that's an argument. The argument here is that the state government rules are there. The government-run institutions, schools and colleges have their rules. You have to wear a uniform in a certain way, and they will not allow any diversion within the classroom. Institutional autonomy is the core argument here.
Now, please take, for example, the Kendriya Vidyalaya, which comes under the ambit of the central government. They also have prescribed rules, and by virtue of an order of 2012, they are prescribed a uniform, and they are allowed to wear a scarf or a hijab over their head. This is Kendriya Vidyalaya, which comes under the ambit of the government. I mean, central government.
Okay.
Now, in Karnataka, this body of the students and of the college, they came up with this arbitrary order suddenly. Isn't that politically motivated? When was these rules? As per our knowledge, these girls were wearing a hijab.
But you have to argue with me like a lawyer, right? This entire argument that it's politically motivated is not something that's going to win you a battle in the court of law.
Correct.
What you essentially have to argue here, for the benefit of our viewers, is the fact that the manner in which the school encroached upon the authority is illegal. But if it's not an essential religious practice, then how it is illegal?
No, see, our primary point is that the Karnataka government circular should go because they don't have powers to issue such a circular. It is arbitrary in nature. Our second fold argument was, if we satisfy the courts that the Karnataka circular is bad in law and the restriction that they're imposing is uncalled for, then there's no necessity for us to get into the essential religious practice. Even otherwise, we put it to court.
So do you think it was a mistake for you at the High Court to go into the ERP argument, the essential religious practice argument? You should have just stuck to the choice argument, what Justice Dhulia is arguing?
No, that's what I'm saying. First point is the Karnataka circular should go. If that goes, there's no necessity for us to get into the ERP test. Even otherwise, if we get into ERP, we are confident that we'll be able to convince the courts of law that wearing of a hijab is an essential religious practice.
Ashwini
but
ji,
that is not necessary at the
moment.
Because,
I'm coming to you.
We are just targeting and attacking the Karnataka government circular, which is bad in law.
Okay, Ashwini ji, I'm coming to you, and this is a very critical aspect on which I'm going to also ask Mr. Ratan Shada to come in. Secularism is a word many argue was inserted into the Indian Constitution. But the subsequent judgments of the Supreme Court, including the Kesavananda Bharti case, the iconic case of the Supreme Court of India, said that secularism has always been the spirit of Indian Constitution. That being said, it doesn't mean that, you are agnostic to all religions. It means you are inclusive of all religions, and at the same time, your decisions are not motivated by religion. What kind of role will secularism, the entire concept of secularism, will play as far as this debate is concerned? Because if you read the judgment of Justice Hemant Gupta, there is a huge part of the judgment on which he elaborates upon what is the meaning of dharma nirpeksh, or the word secular, under Indian Constitution.
Thank you, Anusha ji. Anusha ji, this question you have asked to me or Mr. Ratan Sharda?
To you, Mr. Dubey. Ashwini ji, aapko.
Thank you, Anusha ji. Anusha ji, let me begin with the latest 2017 judgment, because very nicely you have elaborated the institutional autonomy, religious practices at a secular place, and fundamental rights 19(1)(a)(25) of the Constitution of India. In triple talaq case, in 10 seconds I will complete this, discuss the triple talaq. In triple talaq case, what the Supreme Court said, the state shall not interfere with freedom to practice religion, those practices that are merely religious or sanctioned by the religion, but are not mandated to be compulsorily practiced or within the sphere of valid legislation. Point number one. In SR Bomoi case, let us discuss, because the Honorable Justice Dhulia has taken the Ijo Emmanuel's case. In SR Bomoi case, what Supreme Court said? When the state allows citizens to practice and profess their religion, it does not either explicitly or implicitly allow them to introduce religion into non-religious and secular activities. Now, freedom of tolerance of religion is only to the extent of permitting pursuit of spiritual life within the different from a secular life. The Constitution, under the heading Right to Religious Freedom, which is Part 3, which calls the fundamental rights, grant religious freedoms guaranteeing the secured rights to religious organizations to run their educational institution, which you are talking about, the institutional autonomy. So this judgment has in fact encouraged upon the institutional autonomy. Now, the religious educational institutions, as per the tenets of their religion, the management of madrasa, had it been the case, can prescribe any religious dress code for the student, including hijab, niqab.
Interesting.
In
Interesting.
madrasas, educational religious institutions for Muslims provide munshi and maulvi, secondary education, alim, senior secondary education, further higher education of kamil, fazil, which is graduation, and that has been
But
recognized.
these are for madrasas and for minority institutions, so that's a different thing altogether. Yeah.
Their religious practices you can follow, but so far as the secular place is concerned, that one has to abide by the law of the land. That's the judgment. Also, India, Article 1 of the Constitution of India says India, that is Bharat, since centuries has been the sanctuary for several religions, faiths and cultures that has prosperously coexisted. But every fundamental right has said, be it the Shirur Mutt case, be even the Baijo Emmanuel's case, what has been described by Honorable Justice Dhulia, that has not said these two institutes.
On that note, Ashwini ji, Ratan Shada ji, I want you to come into the discussion, and I remember you've made this point many times. I want to ask you an open-ended question. According to your understanding, what is the role and definition of secularism when it comes to the running of Indian Constitution and this country? And the definitions are changing, evolving, dynamically being framed by the court repeatedly. Is the manner in which we have understood secularism, and there are legal commentators, very serious legal commentators who have made this argument that the way we understand secularism is a colonial import. It's not our definition.
Anusha, you have made some excellent arguments today, and most of the arguments have not been answered by the contending parties. You talked about secularism. Indian Constitution did not have secularism word. So to call it fundamental character of constitution means we are going back to our civilizational values, which give respect to all the religions. When Indira Gandhi went to Dr. L.M. Singhvi, father of the current Congress leader, Mr. Singhvi, she asked him to translate the word secularism. He translated it as a Sarva Pantha Samabhav, respect for all religions, treatment for all equal. He did not make it Dharma Nirpeksha. Dharma Nirpeksha means you are non-religious. India cannot be non-religious. This idea of Western secularism, these people are trying to impose on India because the Western concept of secularism came from king trying to keep the church out of their own ambit, which church was trying to overpower. So there is a total difference in the way we defined it, Sarva Pantha Sambhav, and what it is. Secondly, nobody has answered whether the issue was hijab or burqa. You have shown on the pictures, the girls who are protesting, PF5 instigate the protest, they were wearing burqas, not hijab. Because I gave you a school circular which clearly said scarf is allowed. So what is the fight about? Secondly, when you talk of dignity, are the women who are not wearing hijab or who are not wearing burqas devoid of dignity? Are the women, Muslim women who are not wearing burqas or hijab, are they not Muslims? So the entire argument, as you rightly said, in the courts, they have shifted grounds many times. First, they said essential practice. When it was defeated, they said dignity. They said privacy. So they should decide what they want. They basically try to bring in their pressure to slowly creep in Sharia into Indian Constitution, which doesn't work. And it will be exposed whether you have tomorrow the judgment goes in favor or against. It will create a landmark issue because then people will say, okay, secularism can be overpowered by Sharia. That is the entire game being played. Because this year, there was no fight about Sharia, about scarf or, this burqa in those schools.
All right, Shivana, do you want to come in on that point? This entire argument of essential religious practices is a regressive argument. I say it provocatively to get your response on this matter. It's a regressive argument, and it's a way to get some archaic laws somehow affirmed under Indian Constitution. I'm not using the word Sharia, but I'm saying that there is a case to be made that any kind of head covering, especially if you mandate it on school-going girls, is a regressive practice. There are women across the world, say in Iran, who are protesting against it. So is this a backdoor way to somehow legitimize and bring in a more conservative definition of what exactly Islam is in this country, in India?
No, I totally disagree. It all boils down to choice of an individual. If these Muslim girls who are going to school chose to wear a hijab, the state should create an environment safe enough for them to be allowed to do so. And if there are certain people who belonging to the Islamic faith who choose not to wear a hijab and would like to roam freely, they should be allowed to do so as well. Our secularism is positive in nature. Unlike you just mentioned, say, France or Turkey, they believe in negative secularism where displaying any religious symbol outside your house or outside four walls is illegal and you will be penalized for it. But in India, it is the duty of the state to create an environment safe enough for us to practice, preach, and believe any faith or religion. It just boils down to that. Now, what's happening in Iran is people are imposing a certain regressive or patriarchal mindset. But in India, that is not the case. We are giving these women a choice.
When this matter goes to the court, in one sentence, if I were to ask you, when it goes to a larger bench, what will be your key argument? ERP, essential religious practice, or the freedom of choice?
Our key argument, firstly, is to quash the government circular and
on what ground?
To suggest that they have no authority in law to pass such a restriction.
Okay.
Secondly, we're going to argue on principles of reasonable accommodation. And if there is a need to dwell into the essential religious practice, we will dwell into that as well.
All right. Thank you so much, Mr. Shivana, Ashwini Dubey, Abha Singh and Ratan Sharda for joining us on the broadcast. The court does have a very tricky task at hand, but these debates which are happening in the Supreme Court right now are framing the definition of secularism. They are framing the limits to religious freedom in this country, and to what extent Article 25 interacts with 19 or Article 21, right to life, or the freedom of expression and equality. These are fascinating debates that you'll hear in the days to come. With that, it's a wrap on this debate.
What happened in Bhilbu did happen. The High Court in Kolkata has, of course, lambasted your government and the police over the post-poll violence. We are not making this up.
Even in Valmiki Ramayana, it is written that Ravan was Sarva Guna Sampanna. Despite all the knowledge, all the ability that he had no control over his Indriyas. And that's what the Indriyas finally consumed him.
Correct. He wanted something, he wanted it.
Correct.
He didn't think about, yaar, ye dharma hai ki adharma?
You can't annex Ukrainian sovereign territory in a referendum and then bomb missiles across 12 cities, kill about a dozen civilians, and then say, come and talk to us.
Here is someone who's on a mission, here is someone who has vision, and his scope and idea in terms of the small towns of India's to be is very different from what we have seen by leaders in the past.
Good evening, hello and welcome to this very special edition. In a star-studded evening yesterday, CNN News 18 honored the Indians whose contribution cuts an edge above the rest. Climate change warriors, entrepreneurs, entertainers, politicians shared the same stage to celebrate these very special stories of innovation, change and determination. There were a total of 6 categories that were awarded outstanding winners whose contribution was recognized. Let's begin by telling you this one. The one and only electric Ranveer Singh set the stage on fire with his energy and charm. His unique style makes him an outstanding achiever, and he also had some very interesting questions for our managing editor, Zaka Jacob. Don't miss this very interesting conversation.
The CNN News 18 Indian of the Year 2022 Outstanding Achievement goes to Ranveer Singh.
Ladies and gentlemen, can we have a huge round of applause for the one and only Ranveer Singh for bringing to life the legendary Couple Dev in '83. No one could have pulled this off like the one and only Ranveer Singh, ladies and gentlemen. Sir, many congratulations. Many congratulations. Can we have a huge round of applause, ladies and gentlemen? The one and only Ranveer Singh winning Indian of the Year 2022 for outstanding achievement. Good evening, good evening, good evening to you all. How are we doing? Damn, it's good to be back. I love you too. Like so much. I really love Delhi. It's great to be back. Here is where I started my cinematic journey and I'm back here. Band Baja Barat se leke 83 tak. Taaliyan ho jaye. Kya baat hai?
You played many a role.
Sir, may I ask you one thing? I've always wanted to ask you
Oh
this.
my God. Oh my God.
May I?
Sure, sure.
आपकी
please.
इजाजत से
Please.
आपकी इजाजत क्यों ले रहा हूं? आप मेरे से बड़े मस्तीखोर आप हैं, इन लोगों को पता नहीं.
आप मेरे जैसे बात करो तो पूछ सकते हैं.
What